Okay.
I'm messaging a few people.
So this is the third of the eLaw workshops, and we're going to talk a little bit about the two readings by Larry Lessig this week, the Law of the Horse one and the chapters from Code, and we'll talk a little bit more about the assessment in this subject as well. Because one of them, I guess, as a priority we need to think about is the first part of the assessment, which is your basically your pitch for the piece of the wiki that you're going to work on. And it's you're laying out to the group and to myself saying, I want to work on this area. These are, I think, are the important issues. This is the sort of information we should include, and these are the relevant questions. And that gives us an opportunity to talk about it, but also to give you feedback and to say, you should put this in or that in or whatever. So the assessment really works in two halves, and I will, over the next week, I promise, do the rubrics and everything just to show you, you know, what the marking criteria for each of those will be. So you're not going into it blind, although, again, you can, these small numbers, you can just show me what you're doing if you're worried about that. And yeah, the primary idea is the first part is just getting your ideas together for what you will work on for your formal piece, your final piece, and enabling the rest of us to provide some kind of, and particularly me, I guess, to provide some kind of feedback and ideas on what you should do with that. And yeah, I will do the rubrics. It'll give you a much clearer idea of how the criteria fall out. I've hesitated on doing that because I haven't known whether I'd be doing this for 10 students or 60 students, and that kind of changes the way in which I would approach this. And obviously doing it for 3, which appears to be the numbers right now, changes it yet again. So next week we'll talk about scheduling when you're going to do those pitches, which need to be reasonably soon to give you time to work on the rest of the project. And as such, I'm not going to expect that that first assessment piece is going to be extremely polished. I wouldn't in any case. The idea is really to make sure that you've got the plan there for where you're going. Okay. So any burning questions right now about assessment? Anything I've missed or? There are.
I had a question on the wiki site.
Yep.
Whether you've picked one yet. So this week's readings, there's a link to I closed it. The Writing Commons website.
Yeah.
And that recommended like Wikispace, Wikidot, and then Wetpaint. So I was just wondering whether they were something, because I've started to sort of prepare my week.
Yeah, the mode of writing is the same for all of them. So the above the line and below the line stuff and the way of using WikiWords should be the same for all of them. What I'm hoping to be able to use is Google, what's it called, Pages, but it's part of the Google Education Apps suite, which is part of the Google Business Suite. And what Google have done is they've produced these, you pay for access to them, but this set of business apps that ties together all your Google Mail, your Google scheduling, and this thing called Pages, which allows you to present web pages, including wikis. And they've made that available for universities or schools, primarily, to access for free. I've convinced them to let me have access to it recently. And now I've just got the learning curve of learning how to use it and getting it set up. But I anticipate that we'll be able to do that. And that means it won't have to be a paid subscription, nor will it have advertising on it. And it means we'll be able to control the level of publicity is not quite the right word, but the public-private divide. So you're not going to necessarily have anything go out there into the public. Not that anyone would find it, but you don't have. It won't go out there before you're ready for it to go out to the public. So I'm anticipating that Google Apps will be the way it will go, and I'm hoping that'll work. But the fallback position is any of those others that are suggested there, and I'll just buy a small subscription, and we'll see how long it lasts to get that material up there. But I think it'd be really nice, particularly because the whole law school now should have access to the Google apps, that we can build, even if I don't know that there's going to be enough students doing e-law, particularly offered every 2 years, to build anything significant out of e-law. But if we could build kind of a law wiki generally with all little bits and pieces from different subjects, I think we could probably build something rather nice as a project out of that. And one of the things I think is really nice about the wiki group writing project is it preserves information about who wrote what. So your labour, like if you helped us write some school web pages, that's fine. And if we put a little acknowledgement on them, thank you for the students who contributed to this, blah, blah, blah. But with the wiki, you can actually see in the code who wrote what bits, who altered what, and so on. So I think that has a nice longevity to it, and it has the ability for, your work portfolio to say, here's something I've created. Anyway, so that was a long way around the simple question, but I'm hoping the answer is, once I've had a chance to, I'm no longer acting head of school as of next week. Stephen comes back. Yay. I don't have 3 jobs. I'm back to having 2 jobs, and I'll have a bit of time to sit down with all the stuff that Google has sent me to figure that out. I don't think it'll be too hard, because nothing Google does is too hard. That's the nice thing about the way they set stuff up. So what's more, I think, is that the discussions that I think are going to be interesting is, what is the style you write for a wiki? Because it's not going to be an assignment style, but it's also not going to be Wikipedia style, because Wikipedia is written as an encyclopedia, so it's only about facts. It's not about opinions or issues. And we need something that's an academic style, which basically says these people have the following opinions and referenced. But it doesn't necessarily have to be written like an assignment, which will be something that no one else would want to read. No offense to you guys, but the assignment is a weird thing that we make you write in a format that you don't want to write in, we don't want to read, and no one else is ever going to read again. So it's this weird, inauthentic thing that we get you to do for various historical reasons. So I'm hoping to, if we can start doing things like wikis, we can actually do stuff that's useful, that someone else is going to read. I mean, that's the academic world all over. We have to write and publish in academic journals, and the figures seem to show that no one reads academic journals either. So there's this huge publishing industry around publishing stuff that no one reads, but people need to do to keep their jobs, which ultimately keeps Mr. Elsevier and company in profits. But now we're getting back to intellectual property law as a theme. So yeah, next week, I promise, I'll have something better for you in terms of firm deadlines and rubrics, and we can talk then about when you think is the best time, and you guys as the contributors get in first as to what week you want to go and discuss what your project's about, and then figure out when the first paper's due in and so on from there. Okay, so onto the 2 Lessig pieces. There's a strange sort of, it was strange setting up the readings for this course, because in part of me just wanted to set Lessig's code as the book we read, because it's available free for Creative Commons for a start, so there's a good bonus. But it also definitively stated so much of what I think is interesting about this area. And he makes the point in the Law of the Horse article that way back in the days of studying early e-law or cyber law, judges and academics said, why bother studying this? Isn't this just, why do we don't study the law of the horse? Although again, I think studying, if you're into horses and racing and genetics and all the rest of it, it probably would be a really interesting area of study to study law of the horse, but that's completely off the track. Where does e-law fit? We already do contracts, we already do torts. Now, there's been this strange trajectory of e-law as a study since that time, because it's became an incredibly popular topic around the year 2000, and most of the textbooks were written then and were updated up to about 2010, And in the last 5 years, the entire area is bombed. And it's just, there's no new textbooks, there's not much activity. And as you can see, it's not a subject that's bringing in a whole lot of students. We thought it would, but it clearly doesn't, or hasn't in the way we've presented it. Maybe it's just me. And I think the reason for that is that the e-law aspect is now so ingrained in every other area of law that it has become pervasive. People say, well, why would we study the internet and contracts? Because a lot of our contracts are already taking place through the internet. Why would we study internet and different to torts when a lot of the things we're talking about, defamation and torts? Well, where's defamation happening these days? Largely it's happening in Facebook and social media. So why would we take it out and study it as a separate area? So it's become full circle. The question of why study it as a separate area, I think, is a live one again. But I think what Lessig points out, and I hope is true, is that in studying some of the specific issues that regulating technology creates, we learn a lot more about regulation in general. If we look at the very special and strange issues that the internet in particular poses for law, then we get a broader understanding of how the law works, how the law operates. And I think the chapters from Code demonstrate that, particularly when he talks about search and seizure laws and the question of what is the purpose of a search and seizure law? Is it to stop the government searching your property, or is it to stop the government invasively coming into your home and turning your house upside down? And he talks about, the original search and seizure laws go back to the days of George III, where they sent there's an interesting picture, where they send, they set specific warrants, non-specific warrants, and you could just, and they sent the soldiers out and they just turned people's houses upside down looking for anything. And Lessig asks, is it the same thing where if you were able to search a person's computer? And he says, in some ways it isn't, because if you actually had digital searches, you don't know you're being searched. In some ways it's worse, okay? But in some ways you don't have the inconvenience of the government coming and turning your house upside down and searching for stuff, because if you have like a targeted search that's searching just for a particular file, you've got like a state secret file, you want to know who has it, and you're only searching for that file, it's less intrusive. And what all that discussion goes to, as Lessig explores in those chapters, is the way that law was framed, the way our rights were framed, the way constitutionalism was framed, was about a certain set of technologies at a certain time. We changed the technologies and we've got to start reevaluating, well, what were those laws about? And what were the limits of law? So I think one of the benefits of e-law is it starts asking you questions about law and regulation that I think make you a better lawyer generally, even if you don't practice in those fields, because you start thinking about things. E-signatures and identity verification is another great one, because you start asking all those really hard questions about, well, when I do sign something, what does that actually mean? It's one thing to say, offer an acceptance and a signature is a form of acceptance and identifies the person who signed it. Good, fine, okay, learn that, that's how it works. But as soon as you start moving into digital signatures and fingerprints and electronic fingerprints and all the rest of it, you start asking, well, what is a real signature then? What does that mean? What did it mean back when people had checks and checkbooks? Some people still do, and businesses still use them. But checkbooks are becoming, for individuals, an anachronism. They're sort of a thing of the past. And part of that is because the law responded to the way in which identity was verified in a different way to checks than it did in other circumstances. So you guys study checks in contract? Yeah, it used to be a big part of contract and banking law and things like that. And I think, and I'm probably getting this absolutely wrong, so I should probably stop recording while I say this in case I'm giving you the wrong advice. But I think fraud nullifies a check, whereas most other contracts, there tends to be better remedies. You did a bit in commercial law. Yeah, checks are really bad for people who are taking checks, because if there's fraud, they get nothing, even if it's completely reasonable that they take the check in the first case. So from Lessig's point of view, the architecture, the regulatory architecture around checks made checks a dangerous and volatile security risk. So the reason why there was a head-to-head fight between credit cards and checks, and credit cards won, was that basically checks didn't provide enough security for the people accepting them. If you accepted a fraudulent check, you were in trouble. However, if there was fraud and there was a bank transfer, generally the bank takes responsibility for it. And definitely with credit cards, there's a whole lot of insurance around credit cards where, I mean, individuals often get the rough end of the stick, but most of the time, if someone steals your credit card and runs up a whole lot of expenses, the credit card company, as long as you haven't been negligent about that, if they have been hacked, the credit card company bears the loss. So neither the vendor nor the purchaser ends up with a loss. So this is me rambling through an area of law I'm no expert on at all, but we used to do weeks and weeks of goddamn checks in contract law for a thing that was about to become an obsolete piece of technology. But at the end of the day, again, as soon as you had digital signatures and digital identity, you start thinking, well, what's a check? It's a person making a little scrawl on a piece of paper. And people always used to joke, because, you know, the signatures on credit cards never look like your signature because it's on that rough, slippery sort of tape. And, you know, people always joke when people look at the signature on back when, you know, last year when you used to sign things for credit cards, because that's all changed now. And say, oh, it looks nothing like my signature. Ha, ha, ha. You know, I'm drunk and I can't sign my signature correctly or whatever. But there was an acknowledgement that what is a signature? And there's a kind of a weird faith people have. Yeah, tap and go, you just need hands. You don't even need to be the person who owns the card, which raises a whole sort of interesting set of issues. Really. Yeah, a friend lost their wallet recently, temporarily, and then had the horror of what if someone goes down to the local shops and just taps and goes for less than $100 everywhere they go. Fortunately, they found the wallet before that became an issue. But it suddenly became this horrific realisation that you could go down to the shops and you could just get $90 worth of things in a huge number of shops tapping and going, and you know, it would never get traced back to you really, unless you're really stupid. But okay, so I know you know, identity is going to be one of the things we're going to look at in this course, and I think that the questions we ask in e-law are good questions for the rest of our law studies, our law professional life. And myself, my PhD was on censorship. And Lessig's concept of code as a form of regulation was absolutely crucial to my thesis, because it suddenly moved beyond, you know, censorship, which boils down so often to, is pornography good or bad? Should you control pornography? What about free speech? What forms of speech can be controlled? Is pornography free speech? Pornography features so heavily in the censorship discourse. It makes it sound like I'm obsessed by it or something, but it's just, that's what it's all about. And Lessig's argument around code finally gave me a way of moving out of the sort of moral arguments, which are no winners because everyone has a different perspective and everyone has a different attitude and set of beliefs, and you're not going to, except for things like child pornography that you have a pretty broad consensus on. The rest of the field, it's really hard to make hard and fast rules. However, when you start talking about the control architecture and you start talking about the ways in which you control access to adult material, you verify identities in a certain way using adult identification techniques, which, believe it or not, our internet laws say you have to do. Any adult material, whether it's pornography or just anything R-rated that's hosted in Australia, has to have an identity verified check on it under the legislation, which is often something like a credit card check. And back in the bad old days of the internet, there used to be, and I suppose there still are, adult check companies usually tied to pornography companies, where you could sign a subscription with your credit card and they would then verify for the cost of that subscription that you were who you said you were and that you were over 18 because you have a credit card, therefore you hopefully are over 18. Anyway, that whole thing is encoded in our legislation. I have not seen this happen in websites at all in Australia, and part of the interesting solution to our censorship dilemma was everything just moved offshore. All the local adult content in Australia just moved to American servers overnight. There was action taken against a website called teenager.com.au, an adult site that were hosting in Australia. They didn't have an adult verification check. They got a takedown notice. They moved to an American server. They still managed to keep the .com.au URL because it's a separate regulatory regime. And just because the content was hosted in America, it meant that there was no way of regulating the content in Australia. Now the question, and this is relevant to our discussion, I'm not just rambling, honestly, is that legislation successful? And the government's response was it's extremely successful, because what we've done is we've moved all the adult content off of the Australian internet. We've moved it to the overseas internet, but that's fine because that's someone else's problem. So it's a great success, this legislation. But at the end of the day, that changeover, one day someone types teenager.com.au and it goes to it as an Australian server. The very next day they type the same thing and the same content comes from an American server. That end user has no perception that anything's different or it's changed. However, from a regulatory point of view, we've got this fantastic success. And the minister said, we've cleaned up our backyard, we've cleaned all the filth out of Australia and sent it somewhere else, which I guess is one way of looking at it. So the code of regulation, and some of that software code, some of that is built into the way the internet is built and the way the internet is evolving. Some of it is built into legislation. Understanding, and Lessig also talks about economics as another set of regulatory apparatus. The way those three regulatory apparatus interact defines the way in which we regulate in a way that we can't think about if we just look about is it legal or illegal, because that's only a small piece of the picture, that we've got multiple interrelated systems. So it's a bit of a head trip, particularly if you've had, as I did, a very conventional kind of law background, to start thinking about law as, it's almost law from an engineering point of view or law as software, and thinking about law as being a human-created artifact that has a purpose, and it may actually serve the purpose or it might not serve the purpose, but not thinking about it in terms of right or wrong or legal or illegal, moral or immoral, but thinking about it as a regulatory object. So I don't know what you guys think about all of that. I know that was a big ramble from me.
There's an interesting comment when you note about the porn sites moving offshore, and thereby bypassing censorship, or I guess bypassing jurisdictional issues in Australia. There's a website called MovieTube, which is a streaming website for blockbuster movies and television shows. Mm-hmm. Basically, to use an example, the Fast and the Furious movie, the latest one, was out on that website before it was out on cinemas.
Yeah.
In HD, it was in glorious HD. So it's just had a federal court decision in the US shutting it down. Nobody knows who owns it. Nobody knows who the people are. The website is registered in the name of a corporation which is offshore. And anyway, the point is it keeps changing its URL every time it gets shut down or gets taken down or blocked by American servers or whatever. And the interesting response that the MovieTube people put on their Facebook page which only has 6,700 followers, mind you.
Okay.
But I would expect that it's got millions of users.
Yeah.
Because their response was, lucky we don't have to abide by... Sorry, I'll use the exact words so I don't say anything from myself. It was, in case MovieTube is blocked by your broadband provider, we will release a new domain every month. Lucky we are not a US company, so we do not respect US laws.
Yep.
And apparently it's a combined action. It's not a class action, but there's multiple plaintiffs in this, ranging from Walt Disney, Time Warner, and the Hollywood Movies Film Association or something like that. They all put something in the Manhattan Federal Court to shut it down for violation of copyrights, violation of trademark. But the interesting thing that I'll note on this is that they're extremely organized, they're extremely agile, and this is a good mix of IP law and e-law in practice.
Yeah.
So the IP law stuff is quite obvious that they're infringing on their copyrights and it's unlicensed. But from an e-law perspective, how do you put your finger on someone or something that's outside of your jurisdiction? And in reading the week 3 notes, that really resonated with me. How do I put my finger on someone who's outside of my jurisdiction, and how do I manage that? What if a website is like, I have my own website, my own domain, it's hosted through Google. Yeah. So much like the university, I bought a Google Apps for Business. I pay $5 a month and it's great. Okay.
I might have to ask you some questions about it then.
I know nothing about it other than that's it. But my domain is actually hosted out of California.
Mm.
So if I put up a website where I'm defaming another consultant or I publish something, is that actually published in this jurisdiction?
One of the interesting things that in the Reading from Code Lessig talks about is the way in which business is becoming more and more responsible for building some of this architecture into the internet. And the original builders made the internet very free and very open, but the time will come when more of these structures are being built in, and we need to have our VPNs as well. True. We need to make sure that when the concessions eventually come, that it's done in the right way. And one of the points I think that Lessig makes, I think is really, really interesting, is that viruses do surprisingly little harm. Most viruses just get in there and infect your computer and, maybe steal some credit card numbers if they're particularly malicious. But it would be not more difficult to write a virus that just wipes everything on your hard drive. And virus writers haven't done that. But it's only going to take one. It's only going to take one really psycho virus writer to cause massive amounts of damage, and then we're going to get a reaction. Then we're going to get a knee-jerk reaction, and we're going to have a post 9/11 style anti-terrorism reaction to the way in which identity is verified online. So maybe we should be building something now. And yes, we're not going to be able to say it's the land of the free and it's the Wild West and nothing's regulated. But the Wild West wasn't a great place to live. Terrible things happen to people in the Wild West. I watched Deadwood. I know what history was like. So it is inevitable that we're going to put more structures up. The question is, how do we stop the really fascist structures coming in? Some of the proposals that particularly the Australian government want to do in terms of internet filtering are really, really repressive. But if there was a massive cyber terrorism attack on Australia tomorrow, they'd probably win an election on it. It wouldn't even have to be that massive a cyber terrorism attack. People would only have to be mildly inconvenienced during a football grand final, I would imagine, and, not be able to watch the football on their phone. And, there suddenly would be calls for action, and we'd give away our civil liberties by the truckload so we could make sure that we would never have our football interrupted again. That's probably an elitist thing for me to say, but yeah, we need to build the right kind of control architectures. And so, again, I think it was chapters 3 to 5 I recommended out of Code. The whole book, I reckon, is a really good read if you get a chance, and it's not a very hard read. He's a really, I wish more law academics would write like he does, because it's a really sort of, you know, effortless read. And I wish I wrote like him as well, while we're on that track. But yeah, I think those are real issues. And in the early days of the internet, people were basically saying the internet is great because it can't be regulated. Everything's outside of control. And I, you know, I'm a bit of a libertarian myself. And certainly I see the potential for particularly repression of minority groups in society through, you know, censorship laws and sort of invasion of civil liberties. I'm concerned about all that stuff. But on the other hand, I'm also in Lessig's camp to a certain extent of saying we can't just go on and say, you know, having the mafia and the Bratskas and the child pornographers and everyone do whatever they like online so that everyone else can feel that they're all being very free isn't creating a great world. You know, we need international policing. We need to be able to crack down on human trafficking. We need to be able to crack the way in which particularly mobile phone networks and VoIP networks are being used by human traffickers to facilitate their business in a way that takes them outside of the traditional use of warrants and wiretapping. There's a whole lot of law enforcement stuff in there that if we say, oh yeah, but it's great because I don't feel like the government's spying on me. So, well, they're also not spying on the Bratva. They're not spying on the human traffickers, and that's an issue and that's a problem. Maybe I'm just getting old. You know, maybe I'm just getting old and grouchy and getting to the point where I think that maybe we need a few more controls in the world and we need a few more weapons against bad behaviour. But I'm also
wouldn't there be enabling legislation to allow them to spy or monitor human traffickers, drug dealers, child pornographers, and that sort of stuff if they're suspected? I mean, they remove the internet out of it for a moment. What if all this was being conducted in somebody's garage or 200 years ago? They would need still...
That was before the internet, 200 years ago.
Yeah. Reasonable suspicion, probable cause, all the usual elements of a crime. I think the issue is that we're not clued on or not switched on enough to understand how these guys use the internet to enable their business or to enable their corrupt dealings. I'm pretty sure they're not logging in and emailing. I'm pretty sure they're routing messages through different servers and bouncing them off satellites and whatever, you know, whatever's on CSI Cyber that I've started watching, which is really interesting, by the way. You can download it for free. Or you can watch it legally on Channel 10. But the issue is that's the thing that I'm saying. Like, it's not that we don't regulate it, we do, but I think we've just got to go through so many steps before we can go, I'm going to target that person's website or hack their phone line or tap their line or monitor their emails going in and out. Because it's that whole innocent until proven guilty. That's a cornerstone of criminal law. Which is a good thing. Which is a good thing. It is a good thing, yes. But exactly. However, what is the trade-off? Don't tell me a parent that doesn't monitor their kids, SMSs or Snapchats or whatever, or Facebook even. I know I've read stories of parents that deliberately, are friends with their kids simply so they can monitor what goes on to their Facebook page and what they're saying and how gangster they are. And I'll close off with this. The internet has created a dawn of keyboard warriors. So there's a lot of people that talk a big game online, not just in social media, but in, I'll fix it later, but as an example, and I won't use any names. This is a real life example. There was a there was a website, a Facebook post, which talked about terrorism, and sorry, 1 second.
Right. I think before Sam gets back to his example, one of the interesting examples of the difference is the difference in wiretaps. Back in the days when phones ran through exchanges, you could wiretap a phone conversation because you knew it was going from this phone down this wire through this exchange to this person. And now companies have all moved to VoIP. Basically, the packets of data through the mobile networks find their own way through the networks and are very difficult to track. And again, Lessig talks about this and says that the companies have created ways of monitoring those packets purely because they want to monitor the commerce. They want to be able to monitor where their money's going and where their money's being spent and charging people for it. However, that also provides a particular nexus for government then to be able to get a warrant for those records and find out. So he's looking at different ways in which innovations that change the hardwiring of the network or the architecture of the network can benefit law enforcement and regulation along the way. So yeah, okay, back to your example about a website.
It was a Facebook post, and it was talking about Middle East and politics and stuff like that. And obviously, a lot of people get passionate when they get online about Jews, Christians, and Muslims, which is the main three religions in the Middle East. There was a chap. This is a story from a person I know who works for a law enforcement agency at a Commonwealth level. Mm-hmm. There was a chap who made a post. It was 2 or 3 lines that he would not support a political group, but he'd rather support another political group. And the 2 political groups he named were known terrorist organizations in international circles. Not so much in Australia, but they're known in international circles. And they used two key things in his posts. He said, "We would rather train with," and then he named these groups. So when it was, all it took was somebody to screen grab, literally somebody screen grabbed their iPhone or whatever and sent it to this chap and said, "Hey, check this out. This looks a bit sus." Mm. They were able to obtain authorization to hack this guy's Facebook, find out where he lived, and he ended up living locally here in Sydney, surprisingly. And they picked him up, and they picked up every electronic device that he's got in his house. And it turns out this chap had a background in criminology. He was in his final year doing criminology at a university. He was a good student, and he's just got some radical views. Mm. But the question I asked this federal agent was, how did you guys know how to get him? He could have been anywhere in the world. He goes, yep, he could have been anywhere in the world. And he goes, and that's the beauty of the internet, that you don't actually know where anyone is. He goes, from sitting in my house in Sydney right now, I can check into the MGM Grand in Las Vegas on Facebook. There's no geo-referencing. I'm just telling it I'm there, and you will think I'm there.
However, you'll be logging an IP address, which will tell you which company you're going through.
I will.
Through a local company.
Sorry?
If you're going through a local internet service provider, we can at least find out what country your ISP's in. So that's a start. Yes,
that's true. So I get it, but the internet is. I know this is going to sound really silly. Is there an actual e-legislation? I've read the Electronic Transactions Act.
No.
There's nothing. No. There's nothing that governs. There's nothing in place that says this is how you need to conduct yourself, or these are the rules governing usage of the internet. It's got to really come down to policy. What if somebody goes to Telstra and says, I want to host a beauty website, or they just sign up an account, and they end up posting child porn or promoting domestic violence.
So what you got is a collection of different content regulation laws. So you'll have the censorship laws, the media censorship laws, which I have tried to forget about because I spent too many years researching it, but that's about creation of media. You have a set of criminal laws, particularly around creation of criminalised content. You have a whole lot of criminal laws around criminal associations and terror organisations, some of which is kind of a bit dubious from a civil liberties point of view, that criminalises relationships and supporting of different organisations. So you've got this network of different forms of regulation of different behaviour, and some things can end up double dipping. You can do, and there's also telecommunications laws, which show things you can't do using the telecommunications and postal system. So you actually end up in a weird situation where one thing you do could actually breach the content laws. It could breach criminal laws. It could breach telecommunications laws. It could breach state and federal laws, all from one Facebook post. Not to mention it could possibly breach your Facebook terms of service, and could also possibly breach international laws if the international people wanted to extradite you to, stand trial. And we've had that in terms of defamation, with people trying to sue people in Australia, or trying to sue people in different jurisdictions based on speech that's located online. And that's a whole different area. Where is speech from in a defamation sense? Where does that come from? So it is a network of different things. And again, it's like it makes the study of the internet, of e-law as a discrete area, more complicated and more difficult. But it also means that it's just become ingrained in everyday behaviour. So it's just another form of crime. It's just another form of commerce. It's just another form of speech or media. It's become really normalised. I suppose the task, part of what we want to do and think about in this course, is to denormalise that stuff that we experience as an everyday thing. I hear a lot, particularly, I don't talk to teenagers very much, but I spend a lot of time on trains, and I overhear things all the time from teenagers saying, "Oh, but it's okay because if you post it on Facebook, no one can do anything about it." Or it's not a breach of copyright if you don't do this, or all this kind of stuff. People are so used to using this media, and they've come up with their own sort of weird reasons for what they do, and why they can't. No one's going to stop them doing what they do. That sometimes it's a rude awakening. A classic one. I was just fishing for an option, but I think I found one. American law makes particularly in relation to child pornography, a distinction between child pornography, which is real, and child pornography, which is fabricated. So it's a story, or it's a drawing, or it's something that's made up. So under the American Constitution, the made up stuff is whether you like it or not, is protected free speech. If it's real, as in an actual child was victimised in the creation of it, it's not counted as free speech. It's criminal law, and it's not protected speech. And a lot of people operate like that's the way the law is here. In Australia, it doesn't have to be anything near real for it to be regulated as child pornography. In fact, a guy wrote a story on a piece of paper and handed it to another guy. And admittedly, he was in prison already, so there's a whole lot of extra things going on in that case. But he wrote a story of a fantasy on a piece of paper and handed it to someone else. That was actually criminised as child pornography, the same way as if an actual child had been victimised in the creation of it. But people don't know that, because they know what the American law is because they've watched American TV. And it comes as quite a shock to them that, oh, maybe our law is different. That can't possibly be right. I've always accepted that, I can do what I like online in this, that, or the other. There's prosecution of children for creating child pornography with the sexting craze that happened a few years ago with those crazy kids. And it probably still goes on, just no one cares about it anymore. but they were prosecuting underage people. And I'm talking underage 16-year-old, 15-year-olds. I'm not talking about little kids, for taking nude pictures of themselves and sending them to other people under prostitution laws. And this happened in the US. And they got some convictions. And at the time, people thought, but I'm just taking a picture of myself and sending it to my friends, who then, of course, send them to everyone else they know. And that creates all kinds of problems. I didn't think that would send it to everyone. But again, it's that difference. But people are so ingrained in the way they're doing stuff online. And I'm sure there's, I mean, I'm thinking of sort of content regulation examples because that's my background, but I bet there's examples from e-commerce all the time where people say, you know, it's not a real contract and if you don't click this or something, so it's okay, I don't have to pay if I haven't done this, or other fields. Anyway, I realise we're about to run out of time. So
an interesting new development on, I guess it's e-law, but I don't know how it fits into e-law yet, but it will eventually. There's specific legislation in New South Wales and Queensland which talks about payment of subcontractors in the construction industry. And one of the things is that you must either post, hand deliver, or fax your payment claim to the respondent.
Okay.
Every contractor I know emails their payment claim to the superintendent at the end of the month for payment. And the courts have, in its initial stages, from 99 onwards, it's been rejecting email service of the payment claim, saying it's not valid service. So on that, you're able to get it bounced because the adjudicator didn't have jurisdiction to determine it because it wasn't a valid claim, because it wasn't served in a valid way. Okay. Now the courts have adopted a sort of a conventional, I guess, accepting email as a convention of the construction contract, because the Act says, or in any other manner as stipulated by the contract. So even though it may not say in the contract, you must serve your payment claim by email to Scott Beattie on the 25th of each month. They're saying the parties have accepted, or it's an implied term. So the court sort of used the common law to make it fit to suit the modern circumstances. While it sounds very, common law, contract law focused, there's an e-law twist to it. They said, if Scott doesn't own the server, if the Scott isn't registered in the name of Scott Proprietary Limited and it's registered in the name of a hosting company, it's not valid service on Scott. Because you didn't serve it on Scott, you served it on Samuel Proprietary Limited, his hosting server, which the contract makes no reference to.
I guess
because I'm not responding.
This is where e-law makes normal law weird, because it's like you can understand where they would say, yeah, but the person might not have checked their email. But you can also say a person may not have opened their normal mail, their snail mail either, or they may not have had their fax machine plugged in. So as soon as you start asking questions, all the house of cards start crumbling, and we start. Maybe this is why no one wants to do e-law, because you go crazy very quickly. It asks questions that are too big, that you can't answer in an 11-week period and write an exam on and you know, plug through it. It asks you to actually ask serious, difficult questions. And who wants to do that on a Tuesday night at 8 o'clock when it's really, really cold? It is here in Melbourne. So good discussion, guys. Really interesting. So as a recap, have a look at the Lessig stuff. I think that'll make a lot of this, what we've been talking about, clearer. Have a check through that again. Think about that idea of those different forms of regulation of law, economics, and software code interlocking as a set of regulatory systems, rather than just thinking about law in that sort of simple, it's a legal or illegal way. I will set out some further guidelines on the assessment, and next week we will talk about maybe scheduling. Have your diaries ready and figure out when we might schedule when you're going to do your particular little pitch on your project, and we'll just plug away at it. Okay, guys. Good night for everyone, and see you next week.
Good night, everyone.